Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today's guest is going to talk to you about their wills and estates practice and kind of demystifying what you think you may know about wills and estates. So thank you so much, Kavina, here for joining us today, and looking forward to hearing about your practice and just how you got to where you are today.
Yeah, thanks for having me. It's an exciting topic, which everyone will learn by the end of my interview.
Perfect. Now, Kavina, maybe you could start. Just tell us, how you got into law and how did you get to, the firm and partnering up there, and how everything kind of came about, and especially into getting into wills in the States.
Yeah, so my story is definitely unique. It is not the run-of-the-mill student lawyer story. I actually started my career in the banking industry, and then I moved into technology consulting. And I did my project management certifications and became a project manager for an IT company. And then in my early 30s, I decided to go to law school. So I went to law school as a mature student, completely wanted to change my career. But I did initially think, with my tech background, that I would be a technology lawyer, and I would help startups, and I would be this, business lawyer, and deal with, all of these great entrepreneurs that are out there. So I went to Western, I got in, I graduated, and then I started working in a one of the largest law firms in Canada, Borden Ladner Gervais, and in Waterloo, where the tech giants are. And Waterloo has always been known as the little Silicon Valley of Canada, right? So there I was in the heart of it, working alongside some really amazing tech and business lawyers, and I absolutely hated every minute of my life. I just couldn't take it. I thought it was too transactional. It was there was no sort of feeling about it, no family. Like, the client interaction was very cold, very transactional, and just completely didn't go with my personality at all. And as a junior at the firm that I was at, they would always give me the things they didn't want to do. So the high-powered corporate lawyers did not want to write wills and powers of attorney for their clients. They didn't want to deal with probate applications. They wanted to work on their multi-million-dollar business deals. And so as the junior, I would get that work. It's like, my business client needs a will, or someone died in someone's family, or they're dealing with a elderly person with capacity issues, but they're my business client. So I kind of need someone to do this soft stuff. And so that stuff would always go to me, and I really had an affinity for it. I just thought, this is really up my alley. This is something that I can connect with. This is something that brings me really close to the client. And really, I'm a reality TV junkie, and I love reality TV. So, these family situations were really interesting. They were really dynamic. I realized that, families have serious problems. There's a lot of drama involved. So for me, it was like a really natural fit. And I said, you know what, I'm just going to focus all of my energy into learning as much as I can about wills and estates. And so that sort of launched me into this wills and estates practice, where I really focused my energy. And as I got into it, I realized that it's actually the one area of law where you really have to know a lot about every area of law. So in every estate file, there's usually a component that either has to do with real estate law, business law, tax law, family law, or trust law, property rights, equity. So I just started realizing that all the stuff that I'd learned in law school, I actually could apply in each and every one of these files, as opposed to if I was just a criminal lawyer, just a business lawyer, or just a real estate lawyer, that would probably be all I would be doing day in and day out. Like a business lawyer, you're dealing with buying and selling businesses most of your day. Whereas with estates, I just found that every file was unique in the sense that there were so many elements to an estates file. It certainly was certainly was not what I thought it was. I never went into law school thinking I'd be an estates lawyer. I completely thought wills and estates law was like someone sitting there writing a will, that's all it is. But it's actually much broader than that. It's very technical in nature, and it's very expansive in terms of the breadth of the area of law that it does actually cover. So here I am.
Perfect. Thanks for sharing. And I think maybe we can continue on with that because, I think there is that misconception that you're going, pumping out all these wills, changing a few names, and getting someone to witness it, and away they go. What is it like now
Mm.
with Nika Law LLP that you're there with? What is it like in terms of your practice and the clients that you serve?
So for a number of years, I practiced at a mid-sized law firm in Ontario, and I sort of developed and headed up their estates department. And then when COVID hit, I realized that my business and my practice was booming because people were turning their mind to death, incapacity issues because the elderly couldn't get out of their homes to do their banking. And they needed power of attorney documents in place. They needed substitute decision makers. People were sick. People were dying. People were nervous about dying. So wills and estates just absolutely bloomed at the start of the pandemic. And so I took advantage of that. My partner, Nithla, and I decided to become like Brangelina and put our two names together, Nika. And so we became Nika Law. And now we have 4 lawyers moving into 5 lawyers in 1 year. So our day-to-day practice exclusively focuses on wills, estates, and what we call elder law. We meet with clients in the planning phase when they're needing to do a will or needing to do a will update or get power of attorney documents in place. And the analysis that goes behind a will is very extensive. So we really get to understand what the client's net worth is, what are their assets, how do they hold their assets, who are their family members, how many children do they have? How many marriages have they had? Are they in a blended family? Do they have property across the border? Where are their assets? Do they have a family cottage? Are we talking private corporations? Are we talking small businesses? Are we talking employees? So there's a lot of analysis that goes into what the client's state looks like during their life. And then there's that intense conversation about the scenarios of dying. Who dies first? What if you die first? What if I die first? What if we all die? What if there's a family disaster? What if there's a tsunami or a plane crash? What happens in that scenario? And what if your kid dies before you? What if you don't have grandchildren? What if you do have grandchildren? What if you have children with special needs? And so the list goes on. And as you can see, just by my 2-minute questioning, I've already convinced your viewers that making a will is not simple. And so our clients range from, people in their 20s and 30s that are just starting to develop their assets. They may have bought their first condo or their first car. They may be in their first marriage. They may have just had a new baby and they're starting to think, okay, like what if there is a premature death? What am I going to do? So there's the planning aspect for young people. And then there's the planning aspect for the next generation and the middle sort of age group where they may have done wills in the past, but circumstances have changed and they're on another marriage or their kids are older now. And then there's, of course, the elderly that really are in their last years of their life and are rethinking who they want to leave their legacy to and how they want to do it. And then there's another segment of our client base that are sick. They're dying. And they're dying quickly, or they've elected for medical assisted dying and they know the date of their death, and they don't have their affairs in order. And so there's a rush to get somebody's affairs in order on a very short notice basis to assist them fulfill their wishes because their end is unfortunately near. And then the second area of our practice is in estate litigation, where we fight about all those things in court because either there's a will that's gone awry or someone's not happy with it, or there's executors that are not doing their job properly and they're being negligent, or there's disappointed beneficiaries that are ready to challenge a will, or there's fraudulent wills, or I mean, I could go on. There's a lot of litigation when it comes to estates, so that keeps us highly entertained and busy. But on the planning side, it's great because we're being preventative, and because we're litigators, we're saying, okay, we know what everyone's fighting about. So we know that, you telling us to write a will that's going to leave your family cottage to your 5 children in equal shares is going to be a complete disaster when you both die.
Yeah. So it's kind of a two-part question. We certainly covered it there, but maybe you can go little bit more. The difference when someone dies with having a will, right, and without having one, and then the second part to it is why go to someone like you and not to like the run of the mill or the will kits? Like, can I just go and fill something out here, and that everything's going to go to my wife anyways, and then
Yeah.
what's the difference?
Good question, and great question, actually. And that is the question on everyone's mind, right? That is it's exactly what you just said to me. It is the same question on everyone's mind. Like, why do I need to pay $2,000 for a will when I can go to Walmart? Access Law does them for about $100. I could go to Staples. Staples has a will kit for, I think, $75. And the reality is, there is a market for those wills. There are people who don't have a lot. They're alone. They have a bank account where their money goes in. They may have a little bit of savings, or they may have a car and they rent an apartment. That person is ideal for those simple wills. They do not need me. And I 100% commend, I 100% would say, maybe not the Staples will kit. I don't think I would ever recommend that, but I would say go to Access Law. They're an amazing resource for people that just need the simple will. There's Epilogue Wills, another great resource that has a company that was born out of the pandemic, which they do online wills, where you can go online and fill out a form and there's your will. Will Full, I think, is another. There's lots of companies out there that produce simple Ontario wills for the simple case. And they know, and the good thing about these companies is they know their limitations. If you go to Access Law or you go online to Epilogue Wills or Willful, they know when your situation is beyond their reach, and they will refer you to people like me. So estate lawyers like me are useful and beneficial for people who have something else in their life. It's not just everything to my wife, and maybe everything is to your wife on the first instance, but what if you both died? What about your children? Do you need trust? And so I think going to a specialist, and I am a certified specialist. And even if you went to a lawyer that's not a certified specialist, but someone that practices mostly in estates, you're probably going to get a more comprehensive will, and what I would call a safer will, than you would going to your friend down the street, or your real estate lawyer who dabbles in wills, or your business lawyer who has a template will that he could give you. I think that those wills are just not asking the right questions and going deep enough into figuring out what the will should say, as opposed to just who the beneficiaries are. And if you die without a will, the issue is that you have no control over who gets what when you die. And if you don't care, like I tell people all the time, if you don't care who gets what when you die, then fine, don't do a will. If you don't care that your family will have to pay extra legal fees to have an executor appointed and figure, and the order of distribution of your estate will be in accordance with the law, then fine, then don't do a will. That's completely everyone's choice. You don't have to have a will when you die. You're dead, so like what difference does it make to you? So the reason why you leave a will is for the benefit of others, not for yourself. It's for the benefit of the family that you leave behind. Do you want things to be easy for them, or do you want things to be expensive and difficult? And I think that's a choice that people have to make.
And what are some of the sort of consequences that you talked about there? And it's going to be more difficult. What happens when there is no will, for someone who now wants to say, well, hey, my mom passed away, and I guess there was no will, but she obviously owns this house and I think has like a bunch of stocks and stuff. Like, what about
Yeah.
the kids? So what are we going to do now?
Yeah, so I mean, the first thing obviously is they're going to need a lawyer because they're going to have to understand how to navigate that system. And in Ontario, it's a very structured system in terms of who gets what and who has the right to apply to be the representative of the estate. So when you die without a will, you can't really choose who's in charge. Who's the executor? Who's in charge? When you die without a will, there's a pecking order. So, first, it's your spouse or the person that you're living with. And then it's your children, I believe. And then, it goes on, like maybe your parents and your siblings. Same thing with the distribution of the estate. When you pass away, you know, 9 times out of 10, I'll hear people say, well, I would want everything to go to my spouse first. But if you die without a will, your spouse only gets a preferential share and then a percentage, and your children inherit at the same time as the spouse. So there's also this timing thing, right? Like, so if you don't expect your children to inherit your wealth until both spouses die, then you need to have a will, because in the absence of a will, your children's inheritance is escalated to, and not in the same proportion, but in respect of timing, the same as the spouse. So can you imagine a scenario where a wife or a husband actually could use all of the wealth for the rest of their life, and now all of a sudden they're having to share it with their children because there was no will?
Now that's you had mentioned that a couple of places, with the pandemic and online, and I think before I forget, how has that? I mean, even your whole practice really started booming around this time. So other than that, how has that changed how wills can be done and executed now? Right? I mean, do you need to have uh, witnesses in person, or is that still okay to do it online? Or what other changes have come about in terms of COVID and virtual witnessing and things like that to a wills and estates practice?
Mhm. So when the pandemic first hit, the biggest problem that was faced by not only in Ontario but across Canada was the fact that most legislation for wills across the country required physical presence of witnesses at the same time. And so we ended up with this conundrum where you can't write a will unless the two witnesses are present, but then the government has a mandatory stay-at-home order, and the only people that are allowed in your house are the people that are your beneficiaries who can't be witnesses. So now, how do I get two physical people to be witnesses in my presence when the government says I have to stay at home? And so it was a big problem. And so there was an emergency order that the province issued in April of, that allowed virtual witnessing of wills. So you could not sign them online. You still had to have a wet signature, but the witnesses and the testator could be virtual as long as there was certain elements. Like a lawyer has to be one of the witnesses, has to be, or a paralegal. It had to be a licensee of the Law Society of Ontario to be a witness, and the technology had to be audio and visual. And so we still have that today. It's become a permanent sort of change in our legislation. So we continue to be allowed to virtually execute wills, but I think there's a misconception out there that people think virtual witnessing is virtual signing or digital signing, and they're very different things. So we do not permit digital signing of wills. The only thing that we permit with the use of technology is the fact that I could see you sign your will through this type of technology, but you still have to put a wet signature to the paper.
And then do you have to get that paper and then you put your wet signatures later? Is that kind of the
You
next
can
step?
do it one of two ways. So that's one way to do it. It's like the document circulated, but the difficulty with that is that if the person died in between the passing of the documents, there's this gap as to whether or not that's a valid will, because you need the testator and two witnesses' signatures. So the government also has, the province also has allowed counterpart signing, which means that everyone can have their own physical copy, sign it, but then the three copies have to come together and be stapled to make one copy. So it's going to be interesting when these people pass away and those wills are submitted to the court, because the court registrar is now going to get three copies of a will, each with one signature, and that's got to meet one. That's now the will. So yeah, definitely things have evolved, and it will be interesting moving forward just to see those virtually executed wills and the counterpart wills in either in litigation or be challenged or submitted through the probate process.
Yeah. Now you also talked about the estate litigation and where some examples where people might be challenging the will, and whether it's an execution thing or I think the one that I would always give the students is someone had, I think, like a motorcycle accident. I don't know if maybe you remember this story, or I feel it's like the one that I always think about, but someone had a motorcycle accident, and I think their ex got married to them when no one was around, and then now wants
Oh my God.
the money and stuff like that. I think and the children are fighting that because they're like, well, where did you come from? It seems like like a common soap opera or something kind of plot, right? Is the kids fighting with the new spouse about who gets and somebody gets written out of the will, right? I mean, you love reality TV, so what kind of, maybe walk us through like estate litigation? It doesn't have to be something so kind of salacious like that, but where would you go with if you felt that the person, the testator there, didn't really have the frame of mind when they change their will or remove somebody or what have you?
So there's only, I mean, in Ontario, we do subscribe to what's called testamentary freedom. So we do appreciate that people should have the autonomy to make their will the way they want and to leave their assets to who they want. So there's no moral obligations in Ontario to leave for your children unless they're dependent on you financially, or they're minors, or there's only specific circumstances. There's also no obligation to leave everything to your children equally. So we often do find that people want to challenge wills on these grounds, which is why we call them disappointed beneficiaries. But that's not always grounds to challenge a will. You did highlight one of the legal grounds to challenge a will, which is what if your claim is that the testator was not in their right mind, of sound mind, or had, what we call, did they have testamentary capacity to make a will? Were they unduly influenced by was their voluntary mind taken over by someone else to make that will? It doesn't represent the wishes of mom. This will represents the wishes of my, bad brother. So we certainly see will challenges based on grounds of undue influence, grounds of lack of testamentary capacity, or what we call lack of knowledge and approval of the will. We see a lot of litigation with wills that not necessarily that the will is challenged, but we see a lot of litigation where there's multiple executors named to work together and then they just can't. So they end up fighting, and then one wants to remove the other. There's a lot of litigation around trusts in the will and how the executors are managing those trusts. And then I would say the other sort of big ticket item we have, there's two. One is, like you said, we call that the predatory marriage. So there's elderly people perhaps that are being, taken advantage of by people that are looking, they're looking for lonely older adults, widows or widowers, to befriend for financial gains. There's caregiver abuse. There's those kinds of, we call the elder abuse cases. We see a lot of those. And then I would say the other estate litigation matter we see a lot is a will that leaves out a financial dependent. So someone that's you've been supporting, and then all of a sudden they're not left adequately in the will. So you can't treat one of your kids your whole life, support them. They live in your basement. They don't have a job. You pay for all the groceries. They've never paid $1 of rent. You pay their car insurance. You let them use your car. And then you can't die and say everything's equal. Because at the end of the day, you've never treated that child equally. You've always supported them more. So people, when they're making their will, they sort of just they forget that at law you have a financial dependent, and that person may have a claim for more because you've always treated them that way. You can't just die and now say, well, now you go fend for yourself.
And what about like I think you had mentioned the preferential treatment. So there's no way to say, you know what, um, I don't know, whatever day you go to write your will, you had like a big fight with your husband or wife, and you're like, you know what, I just want to give it to the kids instead, and it'll be like this big surprise for them. Like you can't do that either, right? Because they're still your spouse in the end.
Yeah, like I think the spousal thing is interesting because in the absence of a marriage contract, you do have rights under family law to equalize even after your spouse dies, right? So there's that in the absence of a marriage contract. What I can say is that, more and more in today's generation, there's the concept of the prenup, if you want to use that term, is becoming more important as the younger generation realizes that this may not be their one and only marriage like it used to be in the day. I don't think it comes as any surprise to any of your viewers that second, third, fourth, fifth marriages are becoming commonplace for many people, as well as an increase in common law relationships and people that are deciding not to get married, but to live together or to buy a house. So those domestic contracts are becoming more popular and they're becoming more important.
And what happens in a situation like that if you are common law, um, is then, if you're not specifically named in the will, then do you get nothing out of that, or
Nothing. Common law spouses don't have property rights in Ontario. There is a potential opportunity again to sue the estate for support if there's enough evidence to show that you are a financial dependent on this person. So there's a potential avenue for support of a common law spouse. But in terms of property rights, I will say, like, generally, the law does not provide for any property rights for common law partners.
so again, another reason why they would have to go and make sure that the wills are kind of done if that's what they intend to do.
Yeah.
Um, Now, in terms of other litigation aspects, I mean, in terms of once it gets initiated, what's the process like in terms of, does it from that point on in terms of whether it goes to a trial in the end, is there any like mandatory mediation required, or is it just kind of similar to any other civil litigation?
So estates matters generally are commenced by way of application, not by action. There are the few cases that you would commence by action, and so just generally speaking, the difference being that an action where you have a statement of claim and a plaintiff and a defendant, those would normally proceed by way of trial and the final adjudication, whereas estate matters more often than not, I will say, start by way of application. And what that means is that the final adjudication is not by trial unless the judge decides through the course of the application that a trial is required. So in estates matters, the judges expect all of the evidence on the matter to be produced by way of affidavit, and only counsel makes submissions unless a judge requires viva voce evidence. So the process is quite different with actions and applications. Applications, because all of the evidence is in affidavit form, the lawyers you spend a lot of time preparing evidence on a record. So a lot of our litigation day-to-day work is writing the client's affidavit, assembling their exhibits and their evidence in a format that's easy for a judge to understand. In certain courts in Ontario, Toronto being one of them, and I won't list all of the ones because I'm sure I'll get one of them wrong, but I will say Toronto is one of them. Mediation in an estate application is mandatory, and there are quite a few courts that have subscribed to that. And the reason is because most estate litigation should settle. You're talking about the wealth of a deceased person. It's emotional. Families are trying to grieve someone has passed away, and it really just makes no sense in in the eyes of most lawyers and judges for the family to spend the money fighting about it. And in most cases, like, there should be a resolution that's had, and I've been, very fortunate to settle most matters through mediation. And to be honest, like, estate litigation is very expensive. And, back in the day, people used to think, well, who cares? Because all the money will come out of the estate and we'll just dwindle the pot. But a few years ago, the courts ruled that the cost awards in estates would follow the civil litigation regime, in the sense that the loser will pay the costs and that it shouldn't come out of the estate. And I think that that has really impacted the way the litigants in estates view the case, and it has really opened them up to being more amenable to mediation and resolution.
Yeah, because I think that certainly puts something at stake, right? Whereas you're like, well, if I lose, costs come out of the estate, then whatever, I'm not really losing anything. It's they're getting the estate or whatever. It's going to be
Mhm.
more of a loss for them than me. But I think that now has, you have a potential loss if costs are awarded against you, that you have to
Oh,
maybe reconsider if there's merit to bringing this forward, or to rejecting whatever's coming up at mediation, and pressing forward.
yeah. 100%. And like, lawyers are not cheap. We all know that. Where, it's expensive. We bill by the hour. It's not cheap, and it takes a long time, and it is really consuming on your emotional state, because in every case, you're dealing with someone who's passed away, probably someone that's close to you. So it's not the regular plaintiff defendant lawsuit.
Now, what would you say is challenging? I mean, especially when you're dealing with a lot of these emotions, and if it gets to a dispute between the different benefactors or whoever involved, what do you find challenging with what you're doing?
It takes a really unique person to be an estate lawyer. You have to be a part counselor, you have to be part therapist, you have to be emotionally aware, you have to be able to deal with very sensitive issues. Sometimes you're dealing with grown men and women who want to bring up something that traumatized them when they were 10 years old. And I think just being patient and trying to navigate through those issues. If you're the type of person that just has no patience for that kind of stuff, and you're very transactional person, this area of the law is not for you, because this area of the law is all about emotion. Every single case is about emotion. It's about someone's feelings, and there's no litigation that isn't. So in estates. So that is challenging. It's also challenging, to go home every night knowing that, you're probably dealing with, 80 to 200 files that have to do with death, whether it's planning to die, someone's sick, or someone's died, or a family situation. So, it's never really a happy file or good news stuff. It's usually quite depressing and trying, but I think estate lawyers that love what they do, like I do, it's because you can see that through all that hurt and all those feelings and all that sadness and all that grief, that at the end of the day, you're helping the family, and you're there to help, and you're there to hopefully bring some resolution, some peace, and some closure. And so that's sort of what sort of keeps us going and keeps us motivated to the cause. I think John
Maybe that
Clark
last part might
Road.
have cut out there, but
That's okay.
okay, no worries. I think, I don't know if my connection's cutting out here or yours, but um, maybe the follow up there. You talked about you're dealing with a lot of that. What about your own taking care of your own mental health? Where you're saying that there's a lot of death there. What do you do? I mean, besides maybe reality TV, there. What
Uh,
else do you?
you know what? I exercise twice a day. I get up in the morning, I hit the gym. I love boxing. at night we run together, or I'll go do a yoga class or something like that. But I definitely think exercise is like my go-to, and it's where I've always sort of like focused a lot of my energy. And yeah, it's important, I think, to have some balance and put on your headphones and go for a run, or do something non-law. And it's not just in my area of law. I think it's lawyers generally, we work very hard, and I respect every area has its own unique challenges and long hours and late nights and complexities. And I think lawyers in general struggle with work-life balance. So it's important.
Now, one of the things I think from some of the students, so I do have some law clerk students who are interested in wills and estates, and they were learning like what are the program, a database and will builder, all those things like that. But what can they do to kind of be more attractive candidates for firms that may be looking to take on clerks to assist with wills and estates and litigation like that?
Um, I would say for clerks, if anyone that's coming into our firm with an application, whether it be for an assistant role or a clerk role or a lawyer role, we look for people who really understand those concepts. Like, do you understand what a will is, what a power of attorney is, what are the differences, what is a person, power of attorney for personal care? It's not so much the technologies and the tools that matter, because I think that those things can be learned, and they're probably unique from firm to firm. We don't subscribe to Will Builder or any software that would produce a will. We think like the importance of the document requires careful drafting. But I think concepts are important. And then if anyone's looking for a job in litigation, just understanding court procedure, having familiarity with the rules of civil procedure is completely invaluable. And people will never be able to keep up to date with the procedure at the courts, because they change like every day. Every courthouse seems to have their own procedure. And, I feel for them, because I think they're inundated and overwhelmed themselves in keeping up with the case files that Ontarians have put through the system. But having familiarity with the rules of civil procedure and understanding just generally, what is an application versus an action versus a motion, what are the steps to issuing service, filing, what's an affidavit of service. There are certain things in litigation that are consistent and transferable across all practice areas, and those things are so attractive to law firms, because our special area of the law can be taught and you'll learn as you go. But those sort of fundamentals and those basics will really help you accelerate and be efficient to a team.
Now, the other thing I think for lawyers or law students, you've had the background there with a large firm, medium-sized firm, and then partnering up now with kind of your own firm. What can you compare? What you've learned from those sort of three different areas? What's something that you really appreciate now, having the ability to do with your own practice versus when you were at BLG versus when you were at a medium-sized firm? What are the differences there for law students kind of who may find themselves in any one of those environments? What can you kind of share about that?
So, I mean, generally in a large firm, when you're first starting out, the benefit is the exposure to the multiple practice areas and the rotation that you will get. So when you're first starting out and coming out of law school, it's very difficult to know what you want to do. And even when, like what you were telling me before we started, like even when you thought, even when you think you want it, what you think in law school you want to do, until you get into practicing it, you may not have a clue what you want to do. So I think going to the big firms is beneficial in the sense of exposure. And also just the exposure to the types of files that you're going to get your hands on, because there's only certain types of clients that can afford big firm rates. So you're talking about big files, things like that. So and they have fancy offices, and you get cool treats, coffee and parties. And I mean, there's some pretty great perks about being on Bay Street. It's flashy, it feels good. But on the downside, your targets are going to be high. You're going to work really late hours. And sometimes the files are so big that they need multiple lawyers on the file. So, being a junior, the kind of work that you're going to get might be more research related, more administrative work. Um, it's unlikely that you're going to be on the front end of any sort of file. And some of the feedback I've also received is that sometimes you don't really see a file end to end through. You're sort of thrown in to do a little piece for this lawyer and a little piece for that lawyer and research on this lawyer, but you don't really, as a student or a junior, really get the full picture of the file, and you don't really know where your contribution landed or how it helped in the end. And I think that there's a little bit of disconnect that some juniors feel or some students feel when they go through that process with the big firms. But it's cool and it's flashy and it's fun to be in that environment. And I think it's a great experience for everyone to do it. But the chances of burnout are high, and the sort of feeling of being disconnected or being in too large of a pond sometimes catches up with certain individuals depending on their personality and their type. The mid-sized firm is probably ideal for most people because you get a little bit of both. And depending on whether or not the firm is specialized, you can have the same big firm thing in a smaller scale. And then the smaller or boutique firm setting, I think you grow up fast, is what I say to my juniors. You will grow up faster than you would anywhere else because you will have no choice but to learn quickly, and you will see things through, and you will have to, do things that probably a junior is too junior to do just because you're in a small firm environment. So with the right level of coaching and mentorship, I think juniors can do very well in a boutique setting, but they definitely will have to have the sort of the courage to not be on the sidelines and to, like I say, I always use the term, they have to be ready to grow up fast and be prepared for that. So the people we've hired, the juniors, that's what they wanted. Like they were very much focused on, I just want to, be able to go to court myself, run a file myself, meet with a client, not after 4 years of practice. I want to do it after 2 years of practice. I want to feel like a lawyer. And so, the size of the files that we might get at a small firm might be a little bit smaller than the files that you'll get at the big firm, but at least our juniors will see those files through.
Now, with law students, I think this is usually the time with looking for OCIs or articling. And again, I think we were talking before, estates doesn't seem to always be at the top of the list. People don't necessarily know, kind of all the nuances there kind of that we've shared with us today. But what more can you share for those students who are thinking about, they hear estates, they're like, I don't really know what that is. I might have an estates class next semester or something,
Mhm.
but maybe you can further demystify what it's like in terms of what they can expect if they are a little bit interested now of what they can expect if they get into the field.
Mhm. You're I take no offense to the fact that as wills and estates is not on the top of anyone's list. And I don't blame them. It wasn't on the top of my list when I was in law school either. But what I will say is that it is probably not what they think it is. As a solicitor, like I said, it's very technical. If you like drafting and you like if you like legal writing and drafting and being technical in your nature, I think estates can be very challenging and very rewarding when you start trying to draft a multi-millionaire's estate plan, and you're looking at a legacy of a blended family with a multi-million-dollar business with a Florida property and a condo in France and a disabled beneficiary and I don't know, an ex-wife and a girlfriend that you want to take care of. I don't know, but I think it can get really interesting, and every file is very different and it can be very technical on the solicitor side. And on the litigation side, I would say it's super fun, super interesting, very dramatic, very reality TV. And you have to decide if those things interest you because they don't for many people. I think you really have to soul search whether or not you are a transactional type of lawyer or like a broader, like a more touchy-feely type of lawyer, and you want to deal with the soft stuff and you want to, deal with the family stuff. It's very, very similar to family law lawyers when they're dealing with divorce and custody. I mean, those are, I think, are even more contentious than estates. Estates can be a little bit less, they can be just as contentious as divorces and custody battles, but in a different way. Um, but yeah, I would say, if I was to say anything, it would be that I don't think that young lawyers really understand what wills and estates is. And it's similar, I would say, in some ways to the show Better Call Saul that some people watch, but that's getting into some of what we do, but that also is just not real. It's not realistic.
Yeah, I mean, I don't think anyone is trying to be expect. Well, I mean, maybe you expect that to be like Saul Goodman when you're practicing law
Oh
there, but
God.
uh, now one other thing. I mean, I have a lot of paralegal students who are coming back from different careers, and I think something that they can certainly take from you is, as you mentioned from the outset, is that you don't have this traditional path, and same with a number of law students as well. Like a lot of people. One of the things I like to share is that you don't come from this, like you go to undergrad. When I went to law school, it was like go to undergrad, study poli sci, and then 4 years, you'll go to law school, and
Yeah.
everyone's going to be like that. But I mean, there were so many different people with so many different paths. We could share kind of reflecting back on that decision to go to law school at that time and what it was like being a mature student. Because I think, like I said, I have a lot of mature students and certainly a lot of mature students at school right now. Anything you can share share with them from your experience?
I mean, the biggest difficulty is you think about your age and you're like, okay, I was 30, I think I was like 32, and I'm like, am I really going to give up my job that pays well? I have a salary, I have a place, and I'm going to go to law school for 3 years, which is going to cost me, I don't know, 60, $80,000. I'm going to make no money during that time because I'm barely going to be working except for summer and articling. And I'm going to go from this to that. And then I'm going to be with like 22 or 25-year-olds in a class that are all so smart and they've been in school and they're technology proficient. And it was a huge wake up call for me and a big decision to make as to like whether I was going to do that. But I thought, okay, let me just apply and see if I get in first. And then when that happened, I thought, okay, so let me just try 1 year. And if I don't like it, I'll leave. And like once you get past first year, you're just like, oh my God, I put so much blood and sweat and tears into that year. I might as well just finish 2 more years. And so I think changing careers for anyone is a huge step. Um, and people will say, oh, it's never too late, and it's a very difficult decision. And I think if people are thinking about changing careers, it's a decision that really can't be taken lightly and depends on what stage of life you're at. For me, I was at a point in my life where it would be okay for me to take 3 years out and just try something different. And law is one of those areas where you probably won't come out and be struggling. It will probably open a door for you in some way, shape, or form, whether it's as a lawyer or not. Law will 99% of the time open a door for you in your career. And it certainly did that for me. And so, yeah, it's very rewarding, not only on a professional level, but I think coming out of law school, what you learn in law school, how you learn to analyze problems, how you learn to look at situations, how you learn to write, and how you learn to navigate problems just in your life. I think law really helps you.
Perfect. So, Kavita, thank you so much for taking the time here and joining us and sharing all your
Uh,
valuable insight there. I really appreciate it. And I think, again, further demystifying what wills and estates is like. Perhaps if you have any final words of wisdom for any of the people listening and especially any of the students. And thanks once again for taking the time and joining us.
It's my pleasure. I love talking about this, and if I can convince any students to go into wills and estates, I would certainly do so because I think it's an area that will continue to evolve. It will always be there. It will always be needed. It's super fun, super interesting. And if anyone ever wants to sort of send me an email or reach out to say hi or ask a question, I'd be happy to chat.
Perfect. So thanks again. And thanks, Vivian, for organizing everything. And take care, everyone.
Thanks for having me.